So we'll go to Grant then on the enforcement side. So when you have to litigate, you've handled a lot of that litigation, and I know there are some differences between litigating and when there's a counterfeit involved and sort of regular IP litigation. So
Sure.
Can you tell us a little bit about sort of what's unique about it and share some of the tricks that you've learned?
So Courtney gave you a lot of nuance. My job is the hammer. And as a trial lawyer, I tend to see, when you're the hammer, you tend to see everything looking like a nail. One of the things that I had to learn in handling these types of cases early on was that they are not like your standard, ordinary, run-of-the-mill IP case. In those types of cases, most patent cases that I work on, for example, we have two fairly large companies or two sophisticated companies, one who has IP and is accusing the other of infringing, and the other says, no, I actually don't infringe. Here's the little nuance that makes me slightly different from what's shown in your patent or your trademark or copyright. And we know where they are. The parties know who each other are. They know who to call to institute settlement negotiations, so on. And the litigation tends to proceed through a normal track. When we're dealing with counterfeiters, most of the game for them is staying hidden. And so we end up actually the litigation turns into more of a sleuthing expedition, trying to figure out where these people are, how to serve them, how to get them to stop. Ideally, I only get involved in these types of matters when we're at the bottom of the funnel. We start at the top of the funnel with lots and lots of infringers. And we use the takedown processes from the marketplaces. We use direct reach out to them through their own websites, so on. You can use app detext to identify and contact sellers. And that's usually effective for the vast majority of people, and Lindsay could speak to that as well. Most people, when we contact them, they stop. Most of them don't even realize that they're doing it.
Or they do know they're doing it and realize they got caught, and
they move
with a
on.
cease and desist letter through Amazon, for example, we've taken down tens of 20s of individual listings of the boot hanger that violate our patent, and with one nudge or not a full hammer, but like a tap,
Yeah.
we shut them down. We have not been met with unsuccess actually on Amazon with those individual infringers when you send your nasty gram.
Right.
We see you, we know you're doing it. Oh, I turned this off. You don't need it anyway, I talk so loud.
So what ends up happening is at the bottom of the funnel, we end up with usually larger institutional counterfeiters who have lots of products, and I'll give you an example of one of my cases. We had 65 different infringing products out there, all being sold under the same product or same company name. And the company's name is completely made up. There's no corporation anywhere in the U.S. that really uses that name, usually, when you're talking about counterfeiters. But one of the adjustments that we need to make when we're thinking about enforcing IP rights against a counterfeiter is to pretty early on lose the idea that the case is about recouping money. That's a fundamental change from most patent litigation. We've all heard stories about patent trolls and giant runaway jury verdicts. You might get a runaway jury verdict in one of these cases, but the money isn't going to be in the U.S. The money is going to be probably in China, and you're never going to see it. Chinese government doesn't recognize U.S. judgments. We don't recognize theirs either, so it's fair game. But there's a reason for the way that this business model has evolved. And it doesn't mean it's helpless. What we're largely trying to do is roll up the supply chain. So the people at the end of the chain are the ones that you're actually buying from on Amazon or eBay or so on. But what we sometimes do is, in these lawsuits, they're largely about gathering information. We're trying to find out where they got their product from, and we're trying to expose the web. And we're trying to roll them up through the threat of having to defend the suit, or they're going to get a monetary judgment, for example, to find out who the importer is. Lots of times they'll give us the manufacturer in China. They're not shy about giving us that information because they don't really care, and they know that there's not much we can do to them in China unless we have rights in China. But the importers, almost across the board, they protect them very, very carefully because they got this product, they knew they did something wrong, and they're going to try as hard as they can not to rat out their friends. So the approach is completely different. We're using the litigation not only to get the products down, but also gather information. And monetary damages are a bonus if they exist at all. From a tactics standpoint, one of different things that we use is we'll actually go to the marketplace platforms. For example, Amazon has a reporting tool, and you can report the infringement to them. They're pretty hands-off about it. They'll write back and say, we have forwarded on your complaint to the customer or to the vendor. Here's their email address. Now, if you've been on Amazon, you know their email addresses are not on their storefronts. There's a link that says contact the seller, and you can click that and you can send them a message, but it's encoded and it's all scrambled, so you don't actually know their email address. They're very careful about that. But if you make a complaint and you attach your IP and you explain to Amazon how it infringes, Amazon's not necessarily going to take the definitive action. They don't view that as their role, but they will give you the email address. And that becomes critically important when we get to litigation, because that's the email address they gave to Amazon. They have to get their money from Amazon, right? So you know they check that email. That one's a live link. If you start a lawsuit, you call them a John Doe company, you give the name that they're using for their storefront, most courts will, right at that moment, allow you to open discovery to find out who they are. So you can subpoena the marketplace to get their records. You can send, theoretically, them discovery to the email address and so on, and try to nail down where they are. If you get the information back from Amazon or eBay, you go through the process, you find a street address, you try to serve and you can't find them, which
Like
also
it's a
happens.
UPS store.
Yeah, we had one where it was a UPS store, I think, was the address they gave us. If you document what you've done, and these are fairly easy, low-cost things to be doing, right, is to place a phone call to the number that they've got on file at the marketplace, or send an email, or and the process server costs more, but you need to take that step if you have an address. If you go through all of those steps, we've had success with federal court judges here in the district allowing us to serve by email. And effectively they say, hey, you're doing business in Minnesota through Amazon. Amazon gave these people your address and you didn't accept service. We know you've got a live email though, right? You can hide all you want, but you've got to get paid by Amazon somehow. You got to get paid by eBay somehow. And so we know that you're communicating with the marketplace. And so we're going to allow them to use the email that you gave the marketplace and said, this is my email address. And now that's service. So the reason why that's important is a lot of times they don't show up. You can get defaults, but you can also get injunctions with defaults. And we can then take that injunction, we can use that with eBay, we can use that with Amazon. eBay doesn't recognize patent infringement unless you have a judgment.
Unless you have a court order.
Unless you have a court order, but that can get you the judgment. So this is a completely different model of infringement or of litigation than we usually do, but it can be highly effective if you know what you're doing and you follow the right steps.